What they also didn't see, and I could buy, you could get down to the middle part, you find what you want, you don't read the rest of the floor speech. But Mr. Eaton, in his final remarks, says, now in conclusion, I have just one more reason for passing Resolution 58, that amendment to Article 41. As everyone knows, state legislatures have been losing power rapidly in recent years. And this is not a theory. It is an accepted fact that the progressive decline of legislative power threatens representative government. Many forces aggravate the imbalance, and every time a bureaucrat overspends his budget or ignores a statute, he shows disrespect for the legislature. Resolution 58 declares all executive departments and agencies must respect all mandates, powers, and rights of the General Court, the legislature. And I hope as we close the 15th Constitutional Convention, we can adopt Resolution 58, which says that whatever may happen in other states, New Hampshire is still owned by the people and still operated by the elected representatives of the people.
I like this guy.
Yeah, and he went so far that there were some words in the original drafting of the article that lent power to the executive. Mm-hmm. And they removed those powers to make it crystal clear that the purpose of the amendment was to strengthen the legislature and weaken the executive.
Okay. So
and all that was missed. So that the primary purpose of H.R. 13, mm-hmm. House Resolution 13, is to show the manner in which the court missed it.
Gotcha.
Whether, for whatever, by happenstance or whatever, it's one of the things we're always admonished on the floor is you can't tell what's going on in somebody else's head. Or presume motive, because mm-hmm. you can't know. So I won't presume motive. But
this is basically to clarify
the fact of the matter is that
powers of the branches are.
The fact of the matter is that that amendment to the Constitution was put in there to make it clear mm-hmm. that every member of the executive had to follow all of the legislative mandates that we set forth, mm-hmm. and the governor has to enforce them by whatever mechanism he chooses.
So in this case, what we're talking about is that the New Hampshire legislature told the Attorney General to join the lawsuit, and he refused to do that. And right. So we're trying to clarify that he didn't have the right of refusal. He needed to follow the directives that were given to him.
That's correct. And the loyal opposition is saying that, well, this violates separation of powers and that's why it's unconstitutional. I would say, and as Part 1, Article 37 says, that the three powers of government, to wit, the legislative, mm-hmm. executive, and judicial, ought to be kept as separate and independent from each other as the nature of free government will admit. Mm-hmm. Or as is consistent with that chain of connection that binds the whole Constitution in one indissoluble fabric of unity and amity. So once you're trying to find out how to parse how the different branches relate to each other, mm-hmm. you have to go into the balance of the Constitution and figure out exactly how, so now you're forced to read Articles 2 through 78 that describe how, what the powers and obligations of the different branches of government are. That's that indissoluble fabric.
And if we don't do that, then what happens is one branch winds up assuming more power than it was ever intended to have.
That's correct. And so in this case, the operative thing, the proposed mandate for the Attorney General doesn't violate some constitutional premise like quartering soldiers without permission mm-hmm. of the legislature, or it doesn't violate somebody's right to due process. Mm-hmm. So it's not violating any fundamental provision protecting the people.
Gotcha.
So if the governor were going to say, you can't tell me to do this because it violates the Constitution, he'd have to be standing on something not as a separation of powers, because we obviously have the power to tell him to do anything that is otherwise constitutional.
Gotcha. I do. I understand that.
And then Representative Sorg then went on to document how over the last 30 years the judiciary has been encroaching on the powers of the legislature.
And you also, as you presented with Senator Shaheen just in '94,
right,
which wasn't that long ago,
and
used the legislative power to direct.
And after the 1966 amendment. Mm-hmm. And there was nothing in the law that she passed or was part of that gave the Attorney General any discretionary power. We want him to do this if he feels like it. It didn't say that. It said,
go do this.
Go do this.
Right, right. And that's essentially what the New Hampshire legislature had said to the Attorney General is go do this.
Go join the lawsuit.
Go join the lawsuit. Well, I'm really thrilled to hear that you have pursued this and you're continuing to work out this balance, because it's very important to the future of our state that we try to maintain this delicate balance that goes on amongst all of our different branches of government.
To me, the most important thing, and to me probably more important than the federal Constitution, is the state Constitution. It is the direct grant of authority, grant of power from the people of New Hampshire to the government of New Hampshire. Mm-hmm. It says what we can do, what we can't do, and how we're all supposed to play in the sandbox together. And and the important thing for those of us in government to remember, and I like to call some goobers in government. Remember the Muppets, pigs in space, goobers in government. To remember that we're not playing with our power. That's probably one of the most debilitating things that I've seen in the legislature in particular, because that's where I've been. Mm-hmm. But is the tendency of those in government to regard the power that they are wielding as their own power. Mm-hmm. Is probably one of the most dangerous things. Until the 1964 convention and amendment in 1966, the legislature didn't have the power to propose constitutional amendments.
Right.
That was only done by the people through delegates elected for that purpose. Mm-hmm. And the problem is that when we're sitting there in the legislature and we're enjoying the power of making laws, we tend to think of it as our power. Mm-hmm. And it's not our power. One of the things that was most eye-opening to this, we had a proposed amendment to prohibit an income tax. And whether or not you agree with whether or not we should have an income tax, the issue before us was, should the legislature of the state put before the people whether they want to prohibit the legislature from imposing an income tax. And a floor speech by an otherwise fiscally conservative legislator said, we don't want to bind future legislatures this way. And all I could think of was, it's not us doing the binding.
Right.
The most we can do is put a proposal before the people. And it's the people who have the power to bind or not bind future legislatures. And it is their perfect right to do so if they feel that we're abusing the power they've delegated to us to restrict it further.
But as it is right now, we have to rely on the
Well, no, you don't have to. We don't have to.
Whether or not we can restrict them.
There's by Constitution, we have to have the question as to whether or not to have a constitutional convention on the ballot every 10 years.
That's coming up too, isn't it?
This next ballot, there will be a question.
In 2012?
In 2012, do you want to have a constitutional convention? It is the opportunity that the people have the right, particularly to restrict the government from doing things it's currently doing, because it's always hard to get the government to restrict itself, which is what I've observed. I mean, we don't look at it as the people's power that we're
Right.
swinging around. We tend to get very protective of it. We don't think of it as we think of it as the court's power or the executive's power or the legislature's power, rather than thinking of it as the people's power that they've given to these various. I mean, that's one of the things that I found so disturbing in H.R. 13. There's a 1983 court opinion where, having observed what the legislature considered to be some abuses of the courts holding people in contempt of the judiciary, they attempted to define the crime of contempt of court.
Mm-hmm.
And you have to realize, in the Constitution, it gives specific power to the House, the Senate, the governor, and the executive council to hold people in contempt for disrespecting those bodies. It gives no such power to the judiciary.
Really?
Really. And so the legislature said, well, we'll just define this crime of contempt, because the Constitution does says that all crimes must be defined by the legislature.
Mm-hmm.
And the court came back with the opinion that the legislature's attempt to define the power of the judiciary, the powers of contempt, violated their inherent authority. And I find the concept of inherent authority quite chilling. Our Constitution says that all power in government originates in and is derived from the people. If you believe that, Part 1, Article 8, then how can any member, body, or branch of government have what would be considered inherent authority? Another word for such authority would be divine right.
Yeah. I never thought of judges in this sense as being divine rights.
I mean, it's a chilling statement if you read. It's just a paragraph out of H.R. 13, which refers to this court decision.
Mm-hmm, mm-hmm.
But the concept of anybody in government thinking they had an inherent right that did not first come from the people is, which means the people have no power to modify, to diminish or amend that power.
Right. Not if they consider it's a right that they are entitled to, with no other boundaries around it. That's pretty chilling. This has been very interesting, and I hope that we can continue this, and we'll do part 2.
Yes.
Excellent. And I think one of the things that would be interesting also to point out is that a court opinions, right? They don't enact law; they opinion on.
They opine, and that's one of the significant distinctions. By court tradition, I guess you'd say, precedent is set when they come to an opinion out of a judicial action, a court case.
Right.
Something like they're having been asked for an opinion on HB 89 by the Senate does not constitute precedence.
Right. Exactly. Yes.
And that's by their own evaluation. That's just judicial tradition, I guess.
Well, we're getting some good meat here, and I'm hoping that our listeners and viewers are getting a good grasp of what's going on here and how important our Constitution is. And thank you so much, Dan, for all the work that you have done. I know you have just been so stalwart in studying the Constitution and educating us and bringing us back to the position of understanding how valuable this document is for us to be able to preserve our freedoms and to keep our government functioning. And we're going to take a break, and then we're going to come back, and we hope that you will join us for the second part of this as we continue our discussion on upcoming legislation